Bob Weiner joins us as well, my second favorite lady. Just kidding. Bob Weiner, Democratic strategist, columnist, and former communications director for Clinton drug czar General Barry McCaffrey. He, of course, also former chief of staff of the House Committee on Aging. And also Bob is former communications director for both Congressman Rangel of New York as well as Congressman Conyers of Michigan. He was with those gentlemen a while back. Bob, good to have you. How are you today?
Thanks, Alan. After that wonderful introduction of Amy as the finest lady, I was waiting for my introduction as and among the worst scum we ever have is.
I just introduced you in a far more favorable light, though I put you in the wrong gender category. Please forgive me for that. Do you see other states now suing the federal government for not universally applying immigration laws, but doing so selectively? Bob Weiner.
Well, this decision didn't go anywhere near sanctuary cities. What it did do is pretty amazing. This court, what they did was what the administration would like to do but can't politically, what the Congress and the White House would like to do but can't politically, which is come to a solution for immigration. The court threaded the needle and allowed states to actually inspect individuals who are pulled over for something else for immigration papers as well. That's the one thing that they allowed. They did not allow some other things, but they did assert the federal authority in other cases. But neither the Republicans nor the Democrats can reach an agreement on immigration because it is so politically volatile, and the court had to be the one to step in and do it.
The pendulum swing will be essentially characterized as, at what point are we allowing for the president's prosecutorial discretion to morph into what is in actuality a violation of every state's equal protection right as cited in the 14th Amendment, Bob Weiner?
Well, you're right about the pendulum swinging. I think that, Alan, what's happened here is this case, and many commentators have been saying that today, show that there's a precedent now for the court to come out and give a mixed decision also on the health care bill, which you also said you wanted to move toward. And it means that they may do something like a 5-4 on abolishing the mandate, but they might do severability and allow the other provisions of the bill because they do want to allow federal power to accomplish things. This is an indicator of the overall thrust of the court.
The Supreme Court is not allowed to redefine the Constitution because if it can do that, that means it can unilaterally amend our founding document, despite the fact that we have an Article 5 mechanism to do that very thing. Bob Weiner.
Well, you're right. It's interpret the Constitution, not redefine it. But in that
Thank
sense,
you, ladies and gentlemen of the jury.
In that sense, Alan, it's all over the press today, and I in full disclosure, Pat and I really enjoyed being with you guys for dinner the other night. You're very organized, and so is the court, and the press has been saying that even in the time of George Washington, the government had the right to require everyone to buy muskets. And so there has been a precedent in the past for interstate commerce.
It just makes no sense. It's not it has zero correlative relevance to this.
Well, what
that's
the court
under a
has done
separate
is on the other extreme. They've said it's like telling everybody you have to buy broccoli. So it's somewhere between there. But I don't think they're going to allow the mandate anyway. I think they're going to throw the mandate out, and they're going to allow severability for the pre-existing condition and all those provisions and lifetime caps that people and kids on your plans, all the things that are popular. I think the court will allow it to stand, but I think they'll throw the mandate out.